why I'm not drinking water.
Right. Okay, let's give everybody an opportunity to get up and in place. You may proceed when ready.
May it please the court, Matthew Lane for appellant former husband. I'd like to reserve 5 minutes and begin by commending my opponent, Mr. Stevens, for conceding the second issue raised in appellant's brief and not submitting a rebuttal to this point in former wife's answer brief. Since you have to prepare an opinion on the issue, I'll briefly discuss the basis for this concession. The reason for the concession is that the former wife's notice of contempt of the court hearing in this matter failed to comply with the requirements of Florida Statute 49.084, which states that the plaintiff is entitled to have issued by the clerk a notice of action which shall set forth the description of the real property in any proceeding against. Now, the exact issue that's presented to you today was already decided by the Florida Supreme Court in a case Davis versus DeGiuste. The Davis case involved a post-dissolution action, just as this one did, in which the former wife was awarded ownership of certain real property, which had been held by the parties during the course of the marriage as tenants by the entireties. The Florida Supreme Court in the Davis case said, quote, however, in raising a due process challenge to the district court's ruling, the petitioner contends that service of process was by publication and that the notice of the action made no mention of the real property at issue as required by Section 49.08. If that was indeed the nature of the service of process in the original dissolution proceeding, the trial court was without jurisdiction to adjudicate the property rights of the parties. This is exactly what happened in this case. The former wife's notice of action made no mention of the real property at issue as required by 49.084. Very quickly, I'll discuss two other cases on point. In Wiggum versus Wiggum, the wife filed an action for dissolution of marriage that involved the distribution of real property. The published notice failed to contain a description of the party's real property. And the Florida Court of Appeals said, quote, this case involves a defective service of process and a void judgment. The court ruled that due to the defective notice that didn't comply with 49.084, the court didn't have jurisdiction to adjudicate the former husband's property rights. The Wiggum court stated the defective notice violated the former husband's constitutionally protected procedural due process rights. And in Montano versus Montano, the petition for dissolution contained a description of the party's real property, but the notice of publication failed to contain a description of the real property. And the Florida Court of Appeal held that the court was without jurisdiction to make a disposition of the real property. Now, I'd be remiss if I failed to point out that both the former husband and the former wife acknowledge the former husband paid the former wife in full when the former husband returned from the vacation. So there's no arrearage as we stand here. As the former wife's brief clearly points out, the purpose of civil contempt is to obtain compliance. In other words, if you don't pay alimony, you go to jail. Here, both parties acknowledge that the former husband has paid in full. So the former husband is no longer in contempt. Turning to the second issue on appeal, in this case, the former husband and former wife were awarded the marital home as tenants in common in the final judgment of dissolution, which was entered back in 1999. So each party has a 50% interest in the property. In November of 2016, the former husband went on a long vacation, delivered 6 alimony checks to my distinguished colleague, Mr. Stevens, and due to an error at the bank, the checks bounced and the husband was held in contempt of court. At the contempt of court hearing, the judge issued an order which took away the former husband's 1/2 ownership interest in the marital home and gave it to the former wife. Now, once again, there are two Florida Supreme Court cases exactly on point and a multitude of appellate court precedent from this court and others that prohibit the trial court from taking away the former husband's interest. In the case of Damien versus Damien, you have an identical situation to what we're talking about here. In Damien, the husband was held in contempt and his interest in the home was taken away. The Florida Court of Appeal held that the trial court was free to hold the husband in contempt, charge him with interest, sanction him. But once a final judgment is issued in a case, the trial court doesn't have jurisdiction to modify the previous distribution of the party's property rights. Once again, this exact matter was decided in Harmon versus Harmon, where the husband failed to pay alimony and the wife filed a motion for contempt. The trial court found the husband in contempt and ordered the husband to convey his interest in the marital home to the wife. The second DCA held that, quote, the court doesn't have jurisdiction to modify property rights after adjudication of those rights has been made in the final judgment. And the fourth DCA in Mandy versus Williams stated, quote, the well-established rule in this state is that property rights in a dissolution action are absolutely fixed and vested at the time of the entry of the final judgment, and the trial court cannot modify those rights. Now, if you look at the Supreme Court case of Finston versus Finston, it explains the rationale for this. It's because, and I quote, the application of any other principle would mean that there'd be no end to litigation. In Finston versus Finston, they said that the rationale for holding that property rights are fixed and vested at the time of the entry of the final judgment is the same rationale that undergirds the principle of res judicata. Once the time to file a notice of appeal has expired, or the appropriate motion time has expired, the case is over. A court can't go back, or there'd be no end to litigation. Every contempt case would involve going back in and taking away things that happened in the equitable distribution.
You've raised two jurisdictional issues,
Yes.
one on the service and one on the subject matter jurisdiction, the authority to, I assume you would agree that if we were to agree, we'd only need to write on one of those. Which procedurally would you think?
I think what I would do is I would write on the first one, the one about the notice, because that takes care of everything. It was a conceded point. It wasn't even addressed in the answer brief. And what I'd ask you to do is to reverse and vacate those portions of the lower court ruling that awarded the former husband's interest in the marital home to the former wife. That's I would travel on the first one. If
I mean, but what the other issue would also result, the same result, I think.
it does result, it's the same result. The faster, if I was going to do a quick opinion, I'd shoot it on the first one.
Well, I was more asking procedurally what you thought was correct, not necessarily what was quickest.
Although that does play in there.
I'll hit you with a few more and then I'll sit down. In Knorr versus Knorr, the Florida Court of Appeals stated, quote, with regard to the post-judgment contempt order rendered on October 11, 2000, we agree with the former husband. The trial court erred when it ordered the sale of the property identified as the Golden Gate Estate. The property had been specifically awarded to the former husband in the final judgment. The trial court did not have jurisdiction to modify property rights after adjudication of those rights had been made in the final judgment of dissolution. And finally, from the fourth, Thruston versus Conley, quote, the reshuffling of property rights which were settled in the final judgment of dissolution was error. Now, Mr. Stevens showed me two cases yesterday, came across the wire. And what the issue seems to be is if you have the exact same piece of property, if you have the exact same piece of property that was given in the final judgment, then the court can't rejigger. If somehow that's transmuted or changed, then that's a different thing. But the Florida Supreme Court is clear that you can't rearrange the exact piece of property that was given and suddenly go back in and take it away. And they've consistently held that in two Supreme Court cases, which are binding on the trial court. And the rationale is you don't want to just constantly be relitigating these cases. They relitigate themselves pretty much. Thank you.
Thank you very much.
Please support. My name is Eddie Stevens from the firm Ward Damon. I have the appellee, Diane Frank, with me today. Respectfully, this is not a modification. Respectfully, I believe service was appropriate. We pointed that out in our first supplemental submission of authority. Rule 12615 requires a motion to be served by mail. If you look at the record, we exhausted every effort to try to resolve this issue prior to bringing it to court. We served her, and the appellant is an active Florida attorney. She is required by the Florida Bar to keep a email, keep her address.
But that's for legal purposes. I mean, that's for acts as an attorney, not as a party.
Right, and 12615 says to commence a motion for contempt on a support issue, all you have to do is mail to her residence. That was done.
Well, the former husband was a party to the proceeding already.
Correct.
From the earlier proceedings, so wouldn't mailing have been all that was necessary?
Yes,
Be going above and beyond, perhaps in a way that
abundance of caution.
the former husband doesn't think was sufficient, if that had been required, isn't necessarily relevant, is it? I mean, it's nice to go above and beyond, but as long as you do what's required.
I had authority under 12615. In addition, I believe I did everything in my power to advise this person of this action that was going. The only requirement is that within the motion, it says what we're asking to do. And it is very clear in the motion in our record that we asked to transform a portion of the equity of this house to the appellee. Mr. Lane pointed it out, the parties own this property 50-50. That is not exactly accurate. If you look at an old contempt order from 2007, it's record pages 43, 44, 45, you will see that as a result of a previous contempt motion, because this isn't the first time the former husband stopped paying alimony, $40,000 of equity was provided to the former wife as a remedy. So after that juncture, they did not own the house 50-50. They owned the house 50-50, but the appellee owned $40,000 of the appellant's portion. This is not a modification. We did not go in seeking a modification. The cases cited by Mr. Lane, Wiggum and Damien, those involved actual modifications where the court was modifying alimony and changing property rights. This was solely an enforcement of an alimony obligation, and that the court has...
So you're suggesting it was previously done,
Yes.
so why couldn't it be done again?
Well, I'm not suggesting it was previously done. I'm telling you it was previously done, and the circuit courts have very creative powers to resolve contempt. And here you have findings in the order that the appellee was in dire financial straits, and she relied on this alimony for her basic sustenance. And the appellant went on a trip, and that trip exceeded the checks that were given to Ms. Frank, or the appellee. So we knew that there was an intent there. And there was a comment made by Mr. Lane that it was a problem with the bank. That is nowhere in the record and probably an inappropriate argument. The jurisdictional issues about publication, where we talk about Davis, that was an initial service by publication. In this case, service was done initially by personal service. So I really don't think that there's a subject matter jurisdiction problem. I believe we have the notice, the due process. I would like to point out a case that this court issued in October.
So are you or are you not conceding issue 2?
No,
You're not.
12615. And we provided on March 7th a case that was just decided in December, the week we filed our brief. It's called DOR Baker v. Baker. And it teaches us, it's an opinion by Judge DeMorgan, and it says, determining whether a particular method of notice is reasonably calculated to provide adequate notice requires due regard for the practicalities and peculiarities of the case. And in this case, it was a bunch of contempt orders that was just mailed out, and this court affirmed that that was appropriate service to hold these folks in contempt, not take their property away, but put them in jail.
Well, let me ask you that, because that is the question here. What do you cite to that would, in fact, affirm the trial court's decision here to divest the former husband of property rights.
The fourth DCA opinion in Gepfrich, Gepfrich.
And how, tell me how that works in your argument.
Well, if you have an enforcement action, you have to show ability to pay. And in Gepfrich, Mr. Gepfrich put all of his assets in his house, and he was supporting his girlfriend. His girlfriend wasn't paying rent. It was his homestead property. And the fourth DCA upheld the trial court piercing the homestead exemption, forcing Mr. Gepfrich to sell this property and give the proceeds to his wife.
Had Gelfridge, though, had that been the result of property distribution, had that been the result of a marriage settlement agreement?
His obtaining that property?
Yes.
No, he specifically obtained it subsequent, but same theory. In the Siegel case, the court required a party to deplete their IRA, which was part of the marital divorce. And that's Siegel v. Siegel, 700 Southern 2nd 414. And that's normally a protected asset, your retirement, but that's why the powers of contempt are so powerful. That's why the circuit court has this ability to do this. Otherwise, it would be a lion without a tooth.
In this prior contempt order that you discussed on pages 43 to 45 of the record,
Yes, ma'am.
2007, was that appealed?
No, it was agreed to by both parties. It was signed by a judge. It was not appealed.
If that order, I mean, if that order was void, does that just, or entered without jurisdiction, that doesn't necessarily mean that it can be done again, does it?
No, but I believe Florida law provides that it clearly
And
can.
it's agreed, or,
Well, you have these other issues, these other cases that say an ability.
okay, well, if they are correct that generally there wouldn't be jurisdiction, you're not arguing that the mere fact that it was done before would make it okay? That was just a reference point, correct? I mean,
It happened in this case. The
It
fact
happened
that
in this
it
case, but
happened
you're
in
not
this
saying-
case doesn't become law of the case because it wasn't appealed. But that relief is supported by the cases
all
that
right,
we've
that's a
cited.
separate issue. I was just making sure you weren't saying because it happened before,
it's not rule
even
of-
if it's wrong, okay,
It's not
thank
rule of
you.
the case. I'm not suggesting that at all, Judge Kuntz. If you have any other questions, I'm happy to address them, but I think our brief and our supplemental authorities argues our point well.
Thank you very much, we appreciate
It's
your
an
time.
honor to be before you. I love the new digs.
Oh, thank you, we like them too.
I think if you look at the appellee's brief, you'll see that they did not contest the issue about notice. They argued about argument one, they didn't argue about issue two. But if you'll actually look at the brief, what you've got is where they describe the facts. They say, after learning that these checks, this is on page 8, after learning that these checks had bounced for insufficient funds, Diane, through her counsel, attempted to contact the former husband via a residential address, a business address, by telephone number and email listed on the Florida Bar profile. All of these attempts at contact proved fruitless, as the former husband had already embarked on an extensive sailing excursion. And so then it says, the former husband, I'm on page 9, the former husband attempted to escape from reality while at sea, and despite having modern-day technology, the former husband did not respond.
Why wouldn't, under Rule 12.615, mailing the motion be sufficient?
Because they didn't do it. If you look at the brief, what it says is, on page 10, after attempting every possible avenue to reach or contact the appellant regarding the unpaid alimony arrearages due and owing the appellee, including emailing the appellant at the email address that the former husband's required to maintain with the Florida Bar, the appellee properly served the appellant through publication.
Doesn't the certificate of service on the motion, it appears to state U.S. mail?
Okay, they attempted to serve it via U.S. mail.
Which, isn't that what Rule 12.615 requires?
12.615 would require that they serve it by mail at an address that's an appropriate address. Right now, you've had, they never alleged that they served an appropriate address. So that would certainly hurt that argument. Additionally, and it's certainly not something that was argued in the appellate brief, which is there's a concept of preserving error, and if you don't, all of a sudden you come in and say, oh yeah, we really did it. It was never raised, the issue was completely not raised. Second of all, the case law is very clear that there's 2 Supreme Court of Florida cases which say that the rights are fixed and vested. You can't just move them around. You can't issue them as part of a contempt proceeding. And there's precedent in the appellate court cases for years and years and years, as well as 2 Florida Supreme Court cases on point that say that the trial judge did not have jurisdiction to do that. So for those reasons, I would suggest that this case be reversed, and that those portions of the final order of the court taking away the former husband's interest in the marital home be vacated. Thank you.
Thank you. We appreciate your time this morning. Court will be in recess until next week.